All right. Well, good morning, everybody. Thanks for spending an hour with us today on a very niche kind of a topic, but I think an important topic if you're involved with government contracting and work. Obviously, we have a political action committee here at the Commerce and Industry Association. I do all of the ELEC reports. If you don't know what ELEC stands for, but I think most of you on probably do, it's the Election Law Enforcement Commission. Last year was a very interesting year, and I know Rebecca's going to get into a lot of the details, but there was a lot of turmoil at ELEC with their executive director and also just on different cases that they were pursuing as far as contributions, donations, reporting activity. So fast forward, the legislature actually passed a law, the governor signed it, and I don't want to steal Rebecca's thunder in April, but a lot's changed, and I think this was timely. So I want to thank Rebecca Freed for presenting today. If you don't know Rebecca, actually Rebecca helped us with our PAC a few years ago. So she's a very well respected and knowledgeable attorney when it comes to campaign finances. So we're lucky to have her. She's a partner with K&L Gates. She's been there about 7 months. This is her practice. I mean, she's a part of the government contracts and procurement policy practice there at K&L Gates. She's a Georgetown graduate and Tufts. So Rebecca, welcome.
Oh, thank
The
you.
floor is yours, as they say.
Thank you so much. Thanks for having me. I really appreciate the opportunity to be here and walk through New Jersey political activity compliance, and it's in a post-ETA world. And as Tony referenced, ETA is the Election Transparency Act. So if you're here today, I know you are involved in government contracting, you're politically active. Some of what I'm going to tell you today may be familiar, some may be new, but we're going to walk through some highlights of the law, changes. Definitely have time for questions, and don't feel like you need to save them until the end. If something pops into your head as I'm walking through a particular slide, feel free to raise your hand, jump in. I don't mind being interrupted. I would rather have everybody on the same page before we move to a new topic for discussion. So why are we here today? Let's see if my slides will now go. That would be good. All right, so here we go. Why are we here today? Everyone can see that? Okay. I want to discuss some of the recent changes to New Jersey's campaign finance and pay-to-play laws. The focus is going to be on preserving eligibility for New Jersey government contracting opportunities and provide you at the end with some concrete compliance takeaways for your company. And I think the easiest way to really think about all of this is you obviously have the procurement laws that apply to government contracting. We have campaign finance laws, that apply generally when somebody is politically active here in New Jersey, and pay-to-play laws are really at the intersection of the two. So as I walk through the program today, I will talk about general campaign finance laws, pay-to-play restrictions, but you just have to keep in mind that if you're involved in government contracting, if you want to remain eligible for government contracting opportunities, the pay-to-play laws and limits are what are important to you. So today at a really high level, I'm going to give you an overview of political activity. I'm then going to talk about the Elections Transparency Act, go into New Jersey's pay-to-play restrictions, talk a little bit about independent expenditure activity, because I know that's always sort of a mysterious topic for people with a lot of misconceptions. And the Election Transparency Act did change some of that landscape here in New Jersey. And then wrap up with some strategies for compliance. So all of you here today can go back to your companies, your organizations, and really feel like you have some concrete takeaways on what you can do to make sure you're in compliance, and that if you're not, you figure out some strategies to make sure that you get into compliance and you're able to put your best foot forward with respect to government contracting. So what is political activity? Political activity can take the form of direct political contributions. I think everybody knows that. You write a check to a political recipient, it is political activity. In-kind contributions, if you're asked to host a particular event, if you provide food, sometimes even staff time, that would be considered an in-kind contribution if the recipient that's benefiting is a political committee. independent expenditures, and I will talk more about that later, but those are generally expenditures that are not coordinated with a candidate. And they still are political activity, but there's some more flexibility when it comes to independent expenditures because you're not providing any direct benefit to a candidate. When you host a fundraiser, sponsoring a golf outing. This is always one I like to mention. As Tony said, I've been doing this for a long time now, and I think that golf outings often cause the most angst and surprise in this world. I've gotten phone calls many a time, from clients, prospective clients, where all of a sudden they realize they're ineligible for a particular government contracting opportunity. And the comment will be, well, all I did was sponsor a foursome at a golf outing or a hole at a golf outing. What you want to keep in mind, as I have in this last bullet, is just about any time you write a check to or provide a benefit to a political recipient, it is political activity. So along with those golf outings, as you can see, even if you're placing an ad in an ad journal for a political event, you need to recognize that that is all political activity subject to campaign finance and pay-to-play limits. Now, moving into pay-to-play restrictions, and I'm going to go through a lot, really at a very high level. There's a lot of overlap. There are still differences. So please, if you have questions about this during the program, after the program, I'd be happy to chat. So as Tony mentioned, in April of this past year, Governor Murphy, ultimately signed a new law into effect that was passed by the legislature. This law had, I guess, for lack of a better term, had been bouncing around for a few years. It's always seemed like it was going to pass, then it didn't, but it's now here and it's here to stay. So prior to April 3rd of 2023, New Jersey had 3 different statewide pay-to-play laws, 2 pay-to-play executive orders, and we had hundreds of local pay-to-play ordinances in effect. So for those of you whose companies had done business with counties, but mainly with municipalities, I think it was a real nightmare to navigate through many of these local pay-to-play ordinances. So when Governor Murphy signed the Election Transparency Act into law, it really marked the most sweeping changes to New Jersey's campaign finance and pay-to-play laws in nearly 2 decades. And I think everybody really kind of breathed a sigh of relief, thinking it was going to make everything a lot easier and more simple. And it has in certain ways. But I think, quite frankly, what surprised me the most was I figured once all the local pay-to-play ordinances went away, to be honest, I was a little bit nervous about what I was going to do with my practice because I work with so many government contractors navigating through all these local ordinances. And what I found, in this period of time is that although the ETA has simplified and streamlined New Jersey's pay-to-play laws, there's still a lot of questions out there. Government contractors still need to be careful and pay attention to the law and its requirements because we still do have pay-to-play restrictions in effect here in New Jersey. And paying attention to these differences, and I'll talk about this, is especially important in light of Executive Order 333, which the governor signed in June of 2023. And it answered some open questions about what the Election Transparency Act was going to do to the pay-to-play landscape. But it also made it clear that I think many people thought that the ETA would put us in a situation where we were just dealing with one set of pay-to-play restrictions from the executive level to the local level. And that's really still not the case. It's a lot easier than it was before, but there are still nuances. So the key changes that resulted from the passage of the ETA, and this is, I know that the association is going to distribute this program after. This is a good slide, just to always look at as a quick reference guide. So what happened with the Election Transparency Act is that traditional campaign finance limits have doubled and in some cases tripled. And many of you, I'm sure, are already seeing indication of that. If you're seeing events, invitations for political events crossing your desks, your computer screens, you're starting to see that not only candidates, but political party committees and political action committees are now able to receive contributions up to much higher limits. For example, a non-gubernatorial candidate committee can now receive up to $5,200 per election, rather than the $2,600 we saw in a pre-ETA world. I think the biggest change, and I'll talk about this more in a little bit, has to do with political party committees that can now receive up to $75,000 a calendar year. And what I've been hearing from contributors is they are feeling an increased pressure to give more. And I think what's interesting about this is the same time as our traditional campaign finance limits doubled and in some cases tripled, the reportable threshold here in New Jersey has been reduced from $300 to $200. So that's per election to a candidate, per calendar year to a party committee, PAC, or legislative leadership committee. And that reportable threshold, 300 was really the magic number in New Jersey for almost 200 decades, where for the most part, if you stay below 300, you would not jeopardize eligibility for government contracting opportunities, and you would not show up on detailed campaign finance reports, and you would have less to report when you had to do pay-to-play disclosure. So I think when you think about these first two bullets, what I'm finding, it's like this tension almost, where contributors are now being asked to give a lot more because pay-to-play restrictions have been rolled back. Contributors are able to safely give more. But all of a sudden, you give more than 200 rather than 300, you're showing up in the ELEC database, and you also have to disclose that on pay-to-play reports. So one of the things I'm going to talk about and that you should just be thinking about as we move through this program today is really what is the right approach for your company. I have certain clients that have said to me, if we can give more than 300 and we can do so safely, that's fine. We don't care if we show up on a campaign finance report. And I have other clients that say, even if it's safe, I don't care. I don't want to show up on a campaign finance report. I don't want to have to file detailed disclosures. So I'm just going to stick to contributions of $200 or less. There's no right or wrong, but that's when I think of the interesting changes that I've seen with the ETA, where companies are sort of trying to figure out, how they want to participate and what they're comfortable with. The ETA, as I mentioned, has streamlined statewide pay-to-play restrictions. The fair and open process now applies at the executive branch level. We did not have that before. So if you were contracting with the state of New Jersey, with New Jersey Transit, with a state university, you were subject to these reduced pay-to-play restrictions, even when the state used a competitive process to award that contract. And I think what's interesting about this change is that really, by and large, all state government contracts are awarded by a fair and open process. So in many respects, one could say that pay-to-play restrictions at the executive branch level have almost been thrown out the window, which I think is going to be very interesting as we move further into the gubernatorial election that's coming up. As I mentioned before, sorry, go ahead.
Rebecca, this is a very simple question, base level. Does this start with our 2023 reporting, and is this going to extend as far back as January 1st regarding the threshold and some of the new finance thresholds?
That's a great question, and I'm going to talk about that with the annual disclosure, just in a few slides. But basically, what you'll see is with the Election Transparency Act, it did go into effect in April. Some of the provisions were retroactive to January 1st, like the sunsetting of local pay-to-play ordinances, the change in contribution limits for PACs and party committees. It gets a little bit trickier because when it comes to candidates, the changes in the reportable threshold, really that took effect midway through the year, and the increase in contributions to candidate committees took effect after the 2023 primary. So I'll talk about what that means as we get ready for filing in March. And then if you still have questions about that, you can let me know.
Perfect. Sorry
Rebecca,
to jump ahead of you.
Yes.
Yeah, before you leave this slide, the fourth bullet point.
Yep.
Have municipalities, counties, have they complied with this change?
So it's a really interesting question. So with the local pay-to-play ordinances, they've automatically been sunsetted. There's still confusion because some of the municipalities and counties have not officially rescinded their local ordinances. So some of them may still appear in a code book. I've also still seen I haven't seen many government contracts yet this year, because a lot of them at the local level, are awarded for January 1st or July 1st. But I was still seeing a lot of municipalities with old disclosure forms. So what I would say to that, this is still a tricky spot for government contractors. These ordinances are no longer in effect. I know, for example, like in Hoboken, they had a traditional procurement ordinance and a redeveloper pay-to-play ordinance. The Hoboken Corporation Council had issued guidance, basically saying the ETA superseded all of this. And I know the Hoboken Council just recently struck their ordinances from their code book. So I guess the real answer here is local ordinances are no longer in effect because they've been preempted by state law. However, there's still a lot of confusion at the local level, so it still is taking some navigating. I had a situation with a client, not that long ago, who was contracting with a particular municipality in Bergen County. And that municipality had had its own pay-to-play ordinance prior to the Election Transparency Act. The client had made a contribution to a joint candidates committee of 3 candidates running for municipal office in that particular municipality, but had kept that contribution to $200 per candidate. So that was full compliance with the statewide law. And then the municipality wanted to use a non-fair and open process, appoint this client for a contract, and said, you're not eligible because you made a $600 contribution and our local pay-to-play ordinance prohibits contributions in any amount. So basically then I looked at the ordinance, and I said to the client, like, you have to go back to the municipality and tell them, number one, their local ordinances has been superseded and is no longer in effect. Like, here's the direct language from the Election Transparency Act making that clear. And even if the municipality was taking this position for whatever reason that their ordinance was still in effect, the municipality was also misapplying their ordinance. Because it did allow non-reportable contribution. So I'm telling you that story just to demonstrate that it's not always so easy. And sometimes it takes a little bit of explaining and back and forth, particularly as municipalities, I think, are catching up with the change in the law. And then finally, the other key change is rules around independent expenditure activity and reporting have been expanded, which is important to recognize. To the extent that anybody is supporting independent expenditure only committees, or even trade associations or other groups that engage in independent expenditure activity. So I'll talk about that as well. So when we're dealing with pay-to-play restrictions, reportable contributions to candidates are still relevant for determining eligibility for contracts. So you have to keep that in mind. It doesn't mean that all of a sudden now you can just give up to full campaign finance limits to candidates for office. You still need to pay attention to how particular contracts are being awarded. Contributions to political party committees and legislative leadership committees are generally no longer relevant for determining eligibility for contracts. I say generally because I'm going to talk a little bit about redeveloper pay-to-play restrictions and how at the statewide level, there's still a distinction there. But I think this has been a big change because for decades, people were almost terrified to give anything to a political party committee. And now all of a sudden, a lot of the analysis and guidance that I'm giving people has shifted. It used to be stay away from giving to party committees. And now it's really, oh, go ahead. You can give up to $75,000 a calendar year, to a county or state party committee. So I think that's been like a weird mindset shift that a lot of people are still not used to. If a prohibited contribution is made, a refund may cure the violation. This is still the same as it was before. At the executive branch level, a refund must be requested in writing and received within 30 days of making that contribution. When we get within 60 days of a gubernatorial primary or general, there's a blackout period. So it doesn't matter. You know, if you make a reportable contribution to a gubernatorial candidate and for whatever reason, you know, you have non-fair and open executive branch contracts, there's not a lot you can do if you're within that 60-day window. At the county and municipal level, a refund has to be requested in writing and received within 60 days. And contributions to political action committees such as Commerce and JPAC are relevant for disclosure purposes only, but they're not going to jeopardize eligibility for government contracting opportunities. So this is a good also overall pay-to-play summary slide. Now, as we move on to executive branch procurement contracts, eligibility for non-fair and open or appointed contracts may be jeopardized when a reportable contribution is made by a covered contributor to a gubernatorial candidate. This is a big change than what we saw prior to the enactment of the ETA, because it used to be contributions to party committees and legislative leadership committees could jeopardize your eligibility for executive branch contracts. And it used to be that these restrictions were in place no matter how an executive branch contract was awarded. So this has been a big change, particularly for those of you who contract at the executive branch level. Now, I think everybody was sort of hoping that the Election Transparency Act would streamline the definitions of who is considered a covered contributor, but it did not do that. And for those of you who have been around for a while, and that includes me, because I remember when pay-to-play restrictions first went into effect in New Jersey, you know, we had a statute that went into effect in 2004 that wasn't supposed to take effect until 2006, and we were going to have one standard set of pay-to-play rules from the executive branch level all the way to the municipal level. Then what happened was Governor McGreevey signed Executive Order 134, which put more stringent restrictions in place at the executive branch level. 4 years later, in 2008, Governor Corzine signed Executive Order 117 that broadened the definition of covered contributors even further at the executive branch level. And when Governor Murphy signed Executive Order 333 into law in June of this past year, that executive order makes it very clear that when you're dealing with executive branch contracts, here are your covered contributors. You can see that's the vendor business entity, 10% or greater owners of a corporation, any equity owner of a professional corporation, officers, equity members of an LLC or an LLP, a PAC or subsidiary directly or indirectly controlled by the vendor, and then the spouse, civil union partner, or resident child of any individual listed above. So the Election Transparency Act, you're still dealing with this broader definition of covered contributors for executive branch contracts. And the look back period ranges from 18 months to 5.5 years, depending on when you make a contribution and who you contributed to. So that's just something to keep in mind. It's not as scary as it used to be, considering the fair and open process exception. But for anybody who thought, great, the ETA is passed, now we're going to have one definition of a covered contributor under New Jersey's pay-to-play restrictions, that did not happen. So it's still important to differentiate and distinguish, among covered contributors. Now, for executive branch redevelopment contracts. So
Rebecca?
Yes.
I'm sorry.
That's okay.
I'm just trying to figure out the list that you just showed. Yes,
Yep.
exactly. That list.
Yep.
Isn't that essentially what that is, though? I mean, this seems pretty definitive. Where, maybe I'm missing something. Where is the variability? Like, where is the
variability comes into effect if you're also contracting at the county and municipal level. There's a lot easier of a definition. So I think what everybody had hoped was that the ETA would take the definition that applies at the county and municipal level.
That's what I missed.
Right, but it didn't do that. So you're still, if you're contracting at the executive branch level, also county and municipality, you're still dealing with two different definitions of
Okay.
covered contributors.
I'm sorry, I missed that. I
No,
apologize.
no problem at all. No, don't apologize. I'm glad. Look, this is a dense topic, and I've done this presentation before, and I'm happy to have questions, because I said sometimes I feel like either I'm that good or nobody's understanding anything. So the questions are great. Keep them coming. All right.
Thank you.
So another thing that Executive Order 333 did, when the coverage of redevelopment agreements under pay-to-play restrictions was never part of any of the original pay-to-play statutes. Those restrictions came into effect in 2008 when Governor Corzine signed Executive Order 118 into effect. So then I think when the ETA was signed, everybody was wondering, well, what's going to happen with executive branch redevelopment pay-to-play restrictions? And everybody was sort of wondering. And then when Governor Murphy signed Executive Order 333 into effect, he was clear in that executive order about provisions of the pay-to-play laws that apply to procurement contracts that have changed or remained in effect. But that Executive Order 333 was completely silent with respect to EO 118. So really the key takeaway here is, if you are currently participating in any executive branch redevelopment agreements or are interested in participating in any that are already underway, or for which an RFP or RFQ has already been issued, you still need to be thinking about more stringent pay-to-play restrictions and be concerned with contributions to political party committees and legislative leadership committees. And as you can see up here, a New Jersey State redevelopment agreement, it's pretty narrowly defined. It would be a redevelopment agreement with the Sports and Exposition Authority, the New Jersey Redevelopment Authority, or the Capital City Redevelopment Corporation. And what I will say, again, in all the years that I've been doing this, I don't think I've come across anybody who's participating in an executive branch redevelopment agreement. So if you are, I'd love to chat with you about that, but I really haven't seen this being an issue. So it's just something I like to mention to people. But the nice thing about the executive branch redevelopment pay-to-play restrictions is there's not the same kind of look back as there are under the traditional procurement ones. Basically, if you made a contribution that was reportable today to a gubernatorial candidate or a party committee or a legislative leadership committee, and then a week from now, one of these state redevelopment entities issued an RFP for a state redevelopment agreement, you would be eligible to participate in that. It just gets trickier because if something is underway, it could have been underway for 10 years. And if you contributed, you wouldn't be able to be brought on. So I'm not going to spend much more time on this particular slide because, as I've said, I really haven't seen this be an issue for anybody that I work with. But I always like to mention it because you never know if it is something that's on your radar or if you are participating in executive branch redevelopment agreements. Now we're going to move on to county contracts, and this is where things are going to become a lot easier for here on out. So eligibility for non-fair and open appointed contracts at the county level may be jeopardized when a reportable contribution is made by a covered contributor to a county candidate committee. So at this level, we're only concerned with contributions by the vendor business entity, and it's greater than 10% owners. So this is where we don't really care about your officers, subsidiaries. Obviously, if an officer is a greater than 10% owner, that individual is covered. But it's a lot smaller of a group in terms of eligibility. And we're no longer concerned with contributions being made to county party committees. It's candidates only. And the look back period is 12 months. When we move on to municipal contracts, same definition, same law, but we're just focused on contributions that are reportable to candidate committees in the particular municipality where you're looking to contract. So this is where, when the ETA was signed into law, everybody was hoping the definition of a covered contributor would be the vendor business entity greater than 10% owners across the board, from the executive branch level down to the municipal, but it's not. So this is where that definition and paying attention to who's covered, depending on where you're looking to contract, really makes a difference.
So Rebecca,
Yes.
does this mean that we no longer have to worry about contributions made to, like, so for a municipal contract RFP, we no longer have to be concerned with contributions we made to the county's committees, or like political party committees, Republican or Democratic leadership committees, anything like that? They literally have no
exactly
bearing
right.
anymore. Okay.
That's exactly right. So
It's just specifically that municipalities, officers, mayor, committee, etc.
correct.
Oh,
And that's
cool.
where you still have to pay attention. If it's non-fair and open, you want to keep those contributions to $200 or less.
Right. But the municipality can no longer enact its own ordinance. So as long as you're following the state ordinance now, you're in good shape.
You are. I mean, with the
Okay.
one caveat that it might take municipalities a little bit of time to, to catch up. So
Mhm.
you still may be seeing disclosure forms with older language. You still may come into a situation where a municipality may say to you, oh, we don't think you're eligible because you gave to our municipal party committee. And then you would just have to turn around and say, no, that's not
That's not the
correct.
case,
And here's
right.
why. And this is where I'm going to talk about pay to play certification forms. But I'm a big fan, if it's needed, for clarifying language on those forms. You don't want to go above and beyond, or like go above board, I should say.
Mhm.
But if a municipality is using an old form, and if you made contributions that may look like you would be ineligible based on their form, that's where you could kind of take a proactive approach, and put clarifying language on the certification form.
We just ran into this actually with a local municipality. We just submitted for an RFP just for general, services.
Mhm.
So that's why this is very relevant. That's why I have all these questions, because we just went through this with one of our local municipalities. That's why it's good to know.
It happens a lot, and I've seen it a lot. And with clients that I work with, I mean, I've been drafting all different variations of language for certification forms. And we'll talk about some strategies for compliance, where you're never going to really be able to get ahead of every situation. And I think my general perspective is that at the municipal level, like, everyone's doing the best that they can. This has created a lot of confusion. You hear that from talking with ELEC too. But I always tell people, and you'll hear me say this again later, you want to be an informed consumer, and really understand how everything applies to you, so you can take a proactive approach. Because if you get caught up in a situation where you're being told you're ineligible, and then if you move into a whole bid protest situation, you could be right in the end, and they may understand you're right in the end. But if you lose the contract, what difference does it make? It's kind of like the prize is already gone.
Right.
So for those of you who are here today that are government contractors, and I'm assuming that's probably just about all of you, you're still going to be required to fill out pre-contract pay-to-play certification forms. They are required in connection with non-fair and open contracts. That being said, you'll still see them even if a competitive process is used. It's not the biggest deal, but sometimes, again, if you're asked to fill out a pay-to-play certification form, you want to look at the wording and see what you're certifying to, but it's generally not a problem if they throw it in, even if they're not required to. You need to certify that no reportable contributions have been made by a covered contributor. And we're going to, you refer back to the definitions I previously walked through during the relevant time periods. If it's a county or municipal contract, it's 12 months. If it's an executive branch contract, the look back can be 18 months to 5.5 years. And the executive branch chapter 51 EO 333 form also requires disclosure of reportable contributions to PACs within the past 4 years. Pay-to-play disclosure forms are required on a pre-contract basis and an annual basis. So in addition to the certification form, you're also going to have to fill out many times a disclosure form where you're asked to disclose certain political contributions. Now, the pre-contract certification and Form BE disclosure, which is the annual disclosure that's coming up, it's April 1st, actually, this year, does require that you disclose contributions, as you can see here, by the vendor business entity, subsidiaries or PACs that are directly controlled by that vendor business entity, 10% or greater owners of a corporation, equity partners or members of a partnership or LLC, officers, directors. So the directors is a little bit of a different piece that gets added to these disclosures. And I know sometimes that's a sensitive topic for people because your directors may be outside people who are not really otherwise involved in the company that may, have their own companies, may be politically active. And I'll talk about some strategies for compliance there. It's just important to know that these contributions are for disclosure purposes only. Unless somebody is otherwise a covered contributor, disclosing is not going to jeopardize eligibility. So with directors, unless they are an officer or a 10% or greater owner, their personal contributions will not jeopardize eligibility for the company. So that's important to keep in mind. And we're also focused on spouses of any of these individuals. When you're dealing with the pay-to-play pre-contract disclosure form, it's
Sorry,
required.
Rebecca, one more question.
Sure, go ahead.
There used to be children also, children of officers or directors. I see that's not on there. Has that been stricken?
So the children, sometimes it was resident children, and that was more on a local pay-to-play ordinance piece.
Okay.
And then, so for this pay-to-play disclosure, it's always just been the spouses. So that's maybe what you're thinking about. I know at the local
Probably.
pay-to-play ordinances, sometimes it was resident children, sometimes it was just children. And that became crazy too, because under some of those local ordinances, even if somebody had an adult child who was like in their 40s living on their own with their own salary, sometimes if a municipality really wanted to stick it to the vendor, they would rope that in. So you don't really have to worry about that.
And then the last thing is about directors. Is that officially is it directors according to corporate documents, or is it just directors in terms of title, position within a company?
I mean, I think you can go with corporate documents. Where part of the challenge here is the pay-to-play laws don't necessarily always match up with corporate law. So even with officers, when a lot of these laws went into effect, as you can imagine, banks were really up in arms because an officer included a VP. So think about how many VPs there are at a bank. So the law really looks at like your officers, like your president, your CEO, treasurer, secretary, VP, they say with senior management responsibility. So when I work with companies, I think you have some flexibility in terms of how you figure out who is covered, but you want to do that in a thoughtful way. And it can't just be like, okay, Tony is not a director now because he made a contribution that we don't want to have to disclose, but Kathy, who has a similar role to Tony, is covered. So you have some flexibility, but you want to be thoughtful about that. But that's a challenge because I think if you follow corporate books and corporate law, that would always be defensible.
Okay, thank you.
You're welcome. So with the pre-contract disclosure, you're going to disclose reportable contributions by a covered contributor made within the past 12 months to a candidate committee. And as you can see, that varies depending on the level of government, municipality, county, where you're seeking the contract. Political committees. These are not political party committees. A political committee, they're not used very often, but sometimes they'll be formed for ballot referendums or other issues that take place just in connection with a particular election, and continuing political committees, which are New Jersey's version of a PAC. You're no longer required to disclose reportable contributions to political party committees or legislative leadership committees. So that makes a lot of these disclosure forms a lot easier. The ELAC Business Entity Annual Disclosure, this is the Form BE that we were chatting about a little bit before, is filed electronically with ELAC by March 30th of each year. This year, March 30th is a Saturday, so the filing deadline is going to be Monday, April 1st. This form is required for a for-profit business entity that received payments totaling $50,000 or more in the aggregate as a result of government contracts during the preceding year. So this is really important and something that I'm still surprised people don't realize. Even if you're sitting here today and you think to yourself, we have nobody who's politically active. If you contract with the New Jersey government from the state level all the way down to fire districts, school boards, and you receive $50,000 or more in the aggregate as a result of those contracts, you need to file this annual disclosure. The type of disclosure you're going to file is going to then depend on whether you have any reportable contributions. So if no covered individual or the company has made any reportable contribution during the 2023 calendar year, you're going to file what's called the short form BE, where you basically are going to say we receive payments of $50,000 or more, we have no reportable contributions, and you're done. It's one page. If even one covered person, so that could be an officer, a director, their spouse, has made a reportable contribution, and now we're just focused on candidate committees and continuing political committees or PACs during 2023, you will have to file the long form BE, which requires you to disclose contract information and contribution information. So that's just something to think about, and always a starting point, but the thought of no one's politically active, I don't have to think about this, is not true. So you want to keep that in mind. If you have to file the long form BE, you're going to disclose reportable contributions by covered contributors to candidate committees, continuing political committees, and political committees. Those were the committees I talked about that really are formed for ballot referendum just within one election. You are no longer required to disclose reportable contributions to political party committees or legislative leadership committees. For many of you, this may not make a difference because in a pre-ETA world, remember, a reportable contribution to a party committee or a legislative leadership committee would jeopardize your eligibility for executive branch contracts. So many clients that I work with hold contracts at the executive branch level, also county and municipal. So they were never making reportable contributions to party committees or legislative leadership committees anyway, but this is now official based on the change in the law. And as this goes back to the question from earlier, with this year's Form BE, and I actually did speak with ELAC last week because they've issued an updated Form BE, but really hadn't issued clear instructions. Because the reportable threshold changed from 300 to 200 with the passage of the ETA, but that change in the reportable threshold did not take place, or take effect, I should say, until after the 2023 primary, you're going to use two different reportable thresholds for your 2023 calendar year Form BE. So if from January 1st through June 30th, because the reportable threshold was $300 or less, if you have contributions that were $300 or less between January 1st and June 30th, and you have no other contributions to that particular political recipient during the relevant election or calendar year, you do not have to disclose those contributions on the Form BE. But once you get to the second half of the year, anything over $200 is reportable. So, I mean, certainly if someone says, I don't really care, I'm just going to make my life easier and use the $200 threshold for the entire year, you certainly can do that. But this is just something to keep in mind because a lot of people make a decision to keep certain contributions non-reportable, not even for eligibility purposes, but because they don't want it showing up on a report. So ELAC confirmed when I spoke with them that this is the approach that they're taking. When I spoke with them last week, the Form BE have been updated in January of 2024 for categories for political committees. It still showed political party committees and legislative leadership committees. They did tell me that they were going to talk with their IT team about removing those. I don't know if they have yet. And depending on when you downloaded your blank form to complete, it may still be showing up, but you don't have to disclose that. So bottom line is this year's Form BE, you may feel like, oh, I've been doing this forever. It's going to be a little bit different. So you can just keep that in mind. Right. I'm going to move on to independent expenditure activity. An independent expenditure is an expenditure that promotes the election or defeat of a clearly identified candidate. It contains express advocacy or the functional equivalent. So it's basically vote for, vote against, or something that a reasonable person would conclude that was the meaning of the ad or expenditure. And an independent expenditure cannot be coordinated with a candidate or their agents. Now, independent expenditures and independent expenditure committees, which are also known as super PACs, have received a lot of attention in recent years because they may receive unlimited contributions, provided that money is spent only in connection with independent expenditure activity. They obviously can pay, consultants or others who are working with them, but they cannot make any direct contributions to candidates. Now, what happened, this was really in the wake of Citizens United, which was a Supreme Court case from 2010. It sort of opened the floodgates where you're seeing more and more independent expenditure activity. And what happened was certain groups like 501c4 social welfare organizations or 501c6 trade associations may have decided to jump in and make independent expenditures. But their disclosure obligations in terms of money coming in are different than the disclosure obligations of money coming into a political committee that's regulated by the Election Law Enforcement Commission or the Federal Election Commission. So there was a lot of criticism, particularly with 501c4s, that they were dark money groups. They were spending money on independent expenditures. Nobody knew who was behind it. So what the ETA did was basically say any political organization, trade association, or a social welfare organization that spends more than $7,500 in the aggregate per election on independent expenditures is now an independent expenditure committee under New Jersey law and is required to file regular reports with the Election Law Enforcement Commission and disclose all contributions received in excess of $7,500 for the purpose of making independent expenditures. No, this is a mouthful. It's confusing. I think this is a piece where everybody's watching to see what ELEC does during the regulatory process, because the way that this is currently written, if you pay your dues to a trade association like CIANJ, and then CIANJ decides that they're going to run independent expenditure ads promoting or opposing candidates, and your dues were more than $7,500, one could potentially argue that CIANJ would have to register with ELEC as an independent expenditure committee and report the money it received. Now, I focus on for the purpose of making independent expenditures. I think this is going to be the hook in the regulations. And this is all just hypothetical. I mean, CIANJ, I know you're not making independent expenditures. I just throw this out there as an example for all of you when you're now being asked to pay dues to a trade association or write a check to a 501c4 social welfare organization. It's important to understand whether that particular organization is politically active and whether they engage in independent expenditure activity. It's not going to impact your eligibility for government contracts, but you may end up on an ELEC report as supporting an independent expenditure, and you may not otherwise want to. So
okay, I'm sorry.
Yeah, go ahead.
Because we do have at the bottom of our invoices that only 10% of the dues are going to be used for lobbying activities, but that's been there even predates me.
Yeah.
I think that might solve that issue, but I guess my question is, so what you're referring to as an independent expenditure committee, the super PACs, they're signed up as a 501c4?
Not necessarily. So a super PAC traditionally is a 527 political organization. But in order to make independent expenditures, a corporation can make independent expenditures, a C4 or a C6 can make independent expenditures. Like political activity can't be your primary purpose. Lobbying is not an independent expenditure. So
Okay.
if you as a trade association decided, you were really unhappy with candidates in a particular race, and you decided as a trade association, you were going to run ads, vote for candidate X, he's really great for commerce and industry, candidate Y is terrible, that would be an independent expenditure. And
That becomes reportable.
That's correct. And like there was a lot of criticism before this that C6s or C4s could hide almost behind their IRS status because they weren't subject to the same type of disclosure requirements on money coming in as a 527 super PAC would be. So
I'm sorry, Rebecca,
No, go
one last.
ahead.
But if we, because we've done this where we take an issue, right? Could be minimum wage,
Mhm.
paid sick leave, right? Something, if it's an issue and it's an ad around an issue, that's okay.
That's correct. It's
Okay.
an ad and around an issue that would be issue advocacy or grassroots lobbying, and that's truly lobbying. If you take a position and run ads around an issue, let's say leading right up to an election, and you run those ads in a district and they feature the two candidates on the ballot, that potentially
Right.
could be different. And, we can talk, it's a lot of facts and circumstances. And I think this is one place where we're going to see more play out in the regulatory process because it's very broad, but nobody really fully knows yet.
Yeah, I
sort of-
mean, it's kind of interesting because when I was watching the legislation going through, I mean, the takeaway, the reason for this ETA was all about the dark money,
Mhm.
right? It's the super PACs. And I think the criticisms, and I'm curious to get your point of view, was that at the end of the day, you're still not sure. Every candidate has these super PACs. They all come up with these clever names. You can't even keep track of them.
Right.
When I've looked at a couple of them and I see the amount of money, then I kind of go a little deeper and say, well, who's kind of funding them? Then it's starting to be a little bit more transparent. But I mean, so did this solve the problem with the dark money?
I don't think it did because number one, the disclosure threshold is in excess of 7,500. So, I mean, some people may contribute up to that amount, but a lot of people don't. So I think this will certainly lead to some greater disclosure, but not necessarily, completely. So I think we have to see how it plays out. And I think the point of this is we're just in a time here where as contributors, you always want to be mindful who you're writing a check to, but if you're contributing to a C4 or a C, not even a C6, because the trade associations for the most part are engaged in trade association activity, but a C4 in particular, you're going to want to really know how are they
Yeah.
spending funds? Are they engaged in IEs? Because you may show up on an ELEC report, which you may not care about, but you still kind of want to know and go in with your eyes wide open.
And maybe you're going to cover this, but I tell folks like our PAC, right? Commerce NJ is the 527. I know you and I have had this conversation where it really becomes a safe harbor for a contractor, right? Because they're not doing a direct contribution. So I basically explained to them, look, if you want to be part of a community of free enterprise, like-minded people, join Commerce NJ, you give us 1,000, 2,000. I report it on our ELEC to the state, but it's important to let folks know that they're not subject to any additional reporting, I don't think, because the contribution was made to us and not to candidates or committees.
A good segue, and I know you didn't review the slides before, but to the next slide. So there you go. Yeah, we couldn't have planned it better.
Wow, I love it, Rebecca. Thank you.
So there you go. So contributions to Commerce NJ PAC. So an individual corporation, labor union, or another PAC may contribute up to $14,400 per calendar year to Commerce NJ. Now this is different. In a pre-ETA world, this limit was $7,200. So now it's up to $14,400 a year. If you're writing a check upon a partnership or LLC check, that's attributable to an individual partner or member. It should be accompanied by a signed attribution letter. So if that applies to you and you're an LLC or LLP, just make sure you take this extra step. And I know that the PAC will review and vet that, but it's not always easy to tell necessarily how an entity is organized. But I will say ELEC has been cracking down on this, and I've seen PACs get questions in terms of contributions. So that's an area of focus. All contributions have to be voluntary. They may not be reimbursed in any way, shape, or form. That's true with contributions to Commerce NJ PAC or to any political recipient. If your company has individuals who are politically active that choose to contribute as individuals, they may do so, but they cannot submit for reimbursement on an expense report. You cannot give them a bonus or additional increments of salary with the understanding they're going to use that for political contributions. So you want to be mindful of that. Contributions to Commerce NJ PAC are not aggregated with contributions to any other trade association PAC or business industry PAC. So for those of you companies that are participating today, you may support as many PACs as you would like at the $14,400 per calendar year level. We want to be mindful of the regulated industry ban that applies to banks, insurance companies, cable companies, utility companies. You still cannot, as companies, write direct checks to political committees. So that's just something to keep in mind too. I think we had one bank participant I saw registered for today. Contributions to Commerce NJ PAC and pay to play laws. Any contribution greater than $200 per calendar year to Commerce NJ PAC is reportable by the PAC on its regular ELAC reports. That's just what Tony was talking about. And as a vendor business entity, if you contribute more than $200 in a calendar year to Commerce NJ PAC, you will need to disclose that on your pay-to-play pre-contract disclosure forms and your annual pay-to-play disclosure. It's not going to jeopardize eligibility for any government contracting opportunities from the state level down to the local level, but it is subject to disclosure on pay-to-play disclosure forms. And contributions to Commerce NJ PAC are not tax deductible, so you want to keep that in mind as well. Now, I know we're running a little bit short on time. I know we had good Q&A, which I really appreciate, so I will stick around, just to wrap up these next few slides. If anyone needs to jump off and you have questions after, feel free to reach out, but I do want to just make sure we wrap up and answer any other questions people have. So political giving in 2024 and beyond. So as we approach the 2024 primary election here in New Jersey and beyond that, I think as we're looking toward the 2025 gubernatorial election, you are likely, and I'm sure you are already, to receive numerous requests for political giving. I think we all can agree that we have a lot of important issues that are facing our state and the country. We have polarizing political figures and issues. We now have this increase in traditional contribution limits where people and companies are able at the statewide level to give more than they have in decades. And that also coincides with the rolling back of pay-to-play restrictions. So what's been interesting for gubernatorial elections going all the way back, I guess probably trying to think to the it would be the 2005 gubernatorial election. We've been dealing with a landscape with reduced limits for gubernatorial candidates. We really are not going to have that unless vendors have non-fair and open state contracts. So in the past, probably for almost 20 years, right, you've only been able to give 300 to a gubernatorial candidate. We're now going to see a change in that. And I think that will be interesting to see how that plays out and the amount of money that flows into the gubernatorial election. You may be bombarded with requests. You may be uncertain of what impact a specific contribution may have on your eligibility for government contracts. Reputation, because I think this is one of the areas I know Tony had said at the beginning, like this is a really kind of niche, nuanced area. What I find, I guess, interesting about this area, sometimes probably frustrating, is there's black and white, there's a lot of gray, and reputation really comes into effect here and is a factor, because you may do everything right under the law, but if the public is reviewing meeting minutes and you're appointed in a particular municipality or county for a controversial project, if someone's combing through ELEC reports, if a candidate gets into trouble, all of a sudden it becomes, look at all these vendors who gave to this particular candidate. So you just have to kind of figure out what is your threshold there. I have some clients who have told me, I don't even want to be standing on a line looking over. I have other clients, over the years who have said, as long as I'm within the four corners of the law, people could write whatever they want about me in the press. I don't care. I've had a few who really haven't lasted as clients for too long, who are like, not everyone who runs a red light gets caught. Those are not people I enjoy working with or really want to work with. And I don't think that's obviously a good approach to take. You have to be thinking about your disclosure obligations. Take your time to conduct your own due diligence. Political giving is not an emergency. And I know, like, I've seen situations, arise where it's like this mad rush because there's an event that night and a check needs to be cut. A political recipient is always going to take your money after an event. You want to, as I said, be an informed consumer, go in with your eyes wide open. It's much easier to make a decision beforehand than realize after a check leaves your hands or a credit card payment goes online through ActBlue that you made a mistake. Because once you don't have access to, and that's not in your control, it could be harder to get back. So take your time. So
That's actually an excellent piece of advice.
no, I mean, I
Yeah,
think it's
that's-
true. And we've all, look, we're human beings. We rush around. I've seen mistakes over the years, some that are egregious, some that are just so innocent because two committee names look very similar. Or, in the case, I know everybody, when they think about a lot of this, Birdsall always comes to mind, and people will say, well, we never did that. And that's one extreme. But then there was also, the Della Pella case where when I read that case, and I know that goes back many years now, and for those who are familiar with it, reading the fact pattern, I thought, wow, this could have happened to anybody. Based on the facts in that case, there was a company with a system and processes and procedures in place. There was a emergency political event where somebody was out of the office that day, somebody else filled in, somebody cut a check, the Excel spreadsheet auto-populated. So I think that case to me was always a wow, we just have to take a moment, because you can always get send your check the next day, but when you get into this whole rat race of trying to get it back, it can be stressful.
Good
So-
rule is just take a breath.
Yep. Like we often tell kids, right? Like count to 10. If that
Take a
doesn't
breath.
work, count to 20. So some general strategies for compliance as we wrap up here. You want to review or develop, if you don't have one, company policies and procedures for political activity compliance. This is not one size fits all. If you're a smaller company, you don't need a 20-page policy to address this. Figure out what makes sense, what works. You want to review and evaluate your government contracting goals. Where do you currently hold contracts? Where do you hope to be in the future? And knowing you're not going to be able to predict every opportunity that comes up down the road. You want to track company contributions and contributions by covered individuals. Evaluate potential appearance concerns. Remember, even if a contribution is within applicable limits, it still may carry risk. You want to train and retrain relevant people. Remember that just because everyone is trained today doesn't mean that everybody will still be trained tomorrow. People may come and go. Different people may get promoted within a company. And we all have a million things going on. I've done trainings for companies that have sometimes been half-day trainings. And then all of a sudden, 4 months later, somebody who sat through that training and was an active participant makes a political contribution without getting it pre-cleared and forgot. So I know that again seems extreme, but you want this to be a topic of discussion and dialogue. I understand you have many priorities, but you don't want political activity compliance to come into play only when you have an issue or you get into trouble. I've said this a couple of times already, but be an informed consumer. There's no rush. And just like you do research before you buy a particular product or a car or a computer, you want to make sure here that you understand what are the traditional campaign finance limits? What are the reduced pay to play limits? Do those apply to your particular situation? Who is a covered contributor? You always want to understand the type of recipient committee to which you're writing a check. As Tony was talking about some of the C4s or super PACs, I mean, how many committees do we all see that's For a Better New Jersey, the Best New Jersey, For a Better Tomorrow? Like these names are vague. You want to understand, ask your questions, because you want to make sure that when you ultimately decide to cut a check or make a contribution, that you understand exactly where your money is going. You understand what type of committee it is. You don't want to be hit with a surprise down the road where then you're dealing with an issue. And remember, Commerce NJ PAC is a safe place to contribute. Before the passage of this law, contributing to a trade association PAC was always one of the safest places to contribute. It still is, because if you take one step back, and if we go back to the beginning, pay to play laws do sit at the intersection of campaign finance and procurement law. These laws were originally passed because there was concern and criticism that government contracts were not necessarily being awarded in the best interests of the taxpayers or to the most qualified companies. There was a perception that government contracts, particularly those for professional services, were being awarded to the highest contributors, to friends of the mayor or council, and obviously that's overly simplified. But that's the concern, that people are paying by making a political contribution in order to have the opportunity to play with a particular government contract. But when you give to a trade association PAC, your money is going to a pool with other companies. Many of you are competitors. So if you have 10 engineering companies that are all competing for contracts with Bergen County and you all contribute to Commerce NJ PAC, and then Commerce NJ PAC contributes to members of the legislature that represent the county, or even to candidates running for county office, there's not the threat of influence there. And that's something just to think about. So I know we went a few minutes over. We answered some questions throughout. If anybody has additional questions now, happy to answer them. And you also will get this, but you have my contact information. Certainly please feel free to reach out after if there's something you want to discuss, a question you have as it relates to your company.
Rebecca,
well done.
surprisingly, I have a question.
Go
Sorry,
for
Tony,
it.
I didn't mean to cut you off. I'll wait.
Oh,
Go ahead, Cecilia. I'll wait. I've been
okay.
monopolizing
Rebecca,
questions.
could you just go, I know you went over it a bit, but could you go over again the covered contributors? Where do you find information on whether or not someone's a covered contributor or not?
Right. So for covered contributors, you have to just look into the law itself. So at the executive branch level, you're really at this point going to be looking at Governor Murphy's Executive Order 333. That will contain the most current definition of a covered contributor for executive branch contracts. For a covered contributor at the county or municipal level, you can look in the Election Transparency Act. That revised the statewide law, which is known as Chapter 19, for county or municipal contracts. And then for the pay-to-play annual disclosure form, you can look really to the ELEC regulations or the instructions to the form itself. And you'll also get a copy of this presentation that will have the definitions for you.
Thank you.
You're welcome.
Rebecca, my biggest question over the last several years has been with the development of all these PACs and super PACs. We've had quite a number of them that have popped up that we're asked to give money to. And one of my biggest issues with filing my annual reports is I have no idea where they originated from, who are the administrators or, the officers of these PACs. Google search them, you find nothing. There's no phone number, no offices. The state obviously has registration information for each one of these organizations. Is there somewhere that we have access to find that information?
So generally with PACs or super PACs, I always will start by looking in the ELEC database to see if they're registered. You can look if they're not registered there. Are they registered with the Federal Election Commission as a federal super PAC? You can also do a search in the IRS website for 527 organizations, because some of these, if they're not active in New Jersey on a regular basis or at the federal level on a regular basis, may just be registered with and report to the IRS. And then honestly, if you don't find what you need, ask the committee soliciting you. Say, you know what, we'd love to support you, but can you please send us, a copy of your articles of incorporation or your registration statement, and don't be afraid to ask for that information, because you want to have all of that in front of you before you decide to support a particular PAC. And then I also always recommend Google searches, because sometimes, New Jersey has had our fair share of scandals. And I think, I think a few years ago now, there was investigation into some super PACs and 501c4s that were being operated by the same people. I know a number of companies that got subpoenas who supported these particular 501c4s. And on paper, those organizations look completely legitimate. So sometimes it is also trying to understand who's involved, what's being written about them in the public. Not that it's always going to be true, but that also helps evaluate the risk.
Well, I think it's important, Ohan, to your point too, Rebecca, that I think people get confused sometimes when is it a 527, a 501c4? That has to do with the IRS.
Right.
Then you have New Jersey law and the ELEC. It's completely different.
Yeah.
So to your point, and I think you hit on something, Rebecca, that I just wanted to mention, because I've gotten a couple of calls. It's important that, the running joke, if you will, in Trenton is that, it goes to the, whoever provided campaign dollars, right? These local county government contracts. But it's usually, I'm talking about enforcement now from ELEC. And I've seen an uptick with enforcement, even though that this ETA was a year ago. That and it usually comes about when somebody complains about a contract, or somebody says, well, wait a minute, I think there's something that doesn't pass the smell test. And you'd be surprised, to Rebecca's point, that's why you want to dot every I, cross every T, because eventually, even though nobody's paying attention to it, they'll pay attention to it when they have to. And I mean, ELEC's hands are kind of tied at that point. And you'd be surprised at how many penalties are being issued. People didn't do a 24-hour disclosure or something like that. I mean, that's why with our pack, we're pretty, just consistently, we disclose everything, and we don't want to take any chances.
No, I think you're absolutely right with that, Tony. And I think what we are starting to see is that during the pandemic, I know ELEC had a number of complaints and investigations that ended up all being released, just because of what everybody was dealing with, and they didn't have the time or the staff. And then the Election Transparency Act also changed the statute of limitations for ELEC to bring a request for investigation, and it's now only 2 years. So we have seen a wave pretty recently of ELEC going after political action committees, candidate committees. Sometimes it can be as simple as you didn't allocate LLC contributions, or you didn't report full contributor information. But as Tony mentioned with this pre-election reporting, and that's another aspect of the ETA, that I didn't really talk about because it's not really necessarily applicable to government contractors. But the fact that Tony and Commerce, NJ PAC, and the whole team takes reporting with ELEC very seriously, is aware of all of these obligations, that's really good for you as contributors, because you don't want to end up in a situation where you think you're doing everything right, but because the recipient committee doesn't do what they're supposed to do, all of a sudden you get pulled into something where your name is out there on a list, or you're being asked questions.
Yeah, it's kind of interesting. We could end it here because I know we're late. But when I have to get directors and officers liability insurance for the PAC, boy, oh boy, do the insurance companies run the other way.
Yeah.
I mean, you talk about risk, right? And you're thinking to yourself, risk with political action? Like, nobody
Right.
wants to touch it. Nobody.
And they don't really understand what it is. So I think
Right.
really the key takeaways today, it's kind of like we said, like, take a breath, do your homework, do your due diligence. I think don't be afraid to say no. Don't be afraid to ask for more information, but then also be realistic. Like I always tell people, we're living in a time, again, where we're seeing companies and individuals, people have stronger opinions, and people want to jump in and be politically active. So putting your head in the sand doesn't work.
Yeah.
It's only going to make things more difficult when you have a problem or an issue. So I always tell people to tackle this like head on, as you would with any other type of compliance program or objective, for your company or organization.
Well, Rebecca, you were excellent today. So thank
Thank
you
you.
for sharing your great knowledge. Again, this was recorded. I know Kathy and the team will send this out. We'll probably use this, Julia, as our business beat story, because I think everybody should understand what's going on here from the campaign side of it, especially this year. So thank you, everyone. Thank you, Rebecca. And we'll see you at the next event.
Right, thank you, everybody.
Thanks, everybody.
Thank
Bye.
you.
Bye.